Hello, welcome to the Law Professor YouTube channel. In this today's presentation, we want to look at the topic nullity of marriage in Nigerian law. Nullity of marriage in Nigerian law. And to do this effectively, we shall be looking at just the introductory aspects, just to introduce the topic and give you a framework of what nullity entails under Nigerian law. And I would share my screen. I'll share my screen and so that you can follow effectively. Um, okay, so nullity of marriage. The learning outcomes for this presentation are threefold. We want to look at what we mean by nullity of marriage and how it applies under Nigerian law. And would also look at the laws that are regulating nullity of marriage in Nigeria, just a framework of the laws, because when we get to the substance of the topic, we'll still need to use these laws in analyzing our concepts. Then at the end, you will know the different forms of nullity proceedings in Nigeria, particularly as it relates to the statutory marriage. When we talk about nullity of marriage, we are talking about a situation where you say that a marriage does not exist or was existing before, but now it has been annulled. And usually you have a court declaring a marriage as invalid or null or void. And when we say something is null and void in law, we are talking about the fact that it does not um, exist. There's a voidness, there's a vacuum. It does not really exist under the law. And the law of nullity, when you look at every society, when it comes to marriage, they have some rules and some regulations that govern a marriage. And where you do not comply with those rules or regulations, there's a tendency to say that the marriage is void, for instance. And in terms of social evolution, you can say that the law of nullity reflects the social development, the dynamics of society, whether culturally, whether religiously, or politically. It reflects the ideological basis and views of every society. It reflects the evolution of man. What was nullity 20 years ago? What was acceptable may not be acceptable today. And you can see it in so many things that are happening in society today. You talk about in the global world, in the global space, you talk about same-sex marriage, and which hitherto was even a crime, was not acceptable in most societies, but now has found legal traction, so to say, in a lot of Western societies. You talk about child marriage being illegal, not acceptable in a lot of societies today, whereas traditionally in a lot of customs, children as young as 12 and 11 could get married. But now the legal framework frowns at child marriage. You have situations where women could be captured and married off without their consent in some African societies. But today, consent is required for a valid marriage in a lot of jurisdictions. So the laws of nullity reflect, like many aspects of family law, the social evolution of man, the changing nature of society. And one of the things that I must say regarding the law of nullity, especially the one that we imported on regarding statutory marriage, is the fact that it also has a lot of ties with the fact that under English law, marriage was initially indissoluble. It was regarded as a sacred covenant that could not be dissolved. except some fundamental wrong could be identified in addition to that marriage. Wrongs like the fact that if a party could not consummate a marriage, then the marriage will be declared void. Not that there will be a divorce. Divorce was not possible at some point in English history of marital relations. So, but the marriage could be annulled. It could be said that these parties never married. In fact, they are not divorcees. They never married in the eye of the law. So, English law, for instance, therefore, would regard the marriage that was not capable of consummation because one of the reasons why in religiously marriage was celebrated was the fact that it is a divine injunction towards procreation. So where procreation was impossible, it could be annulled. We'll be looking at the contents of what would cause annulment of marriage today, but that just tells you how the view of marriage determines what is regarded as a valid marriage or invalid marriage. So these are some of the things that will be clearly identified in the course of the treatment or the substance of the topic. The laws of nullity reflect the content of the legal framework in the place where the marriage is celebrated. What we call the less loosey celebration is the law of the place of celebration of the marriage will determine what is required of you to celebrate a valid marriage. It governs celebration of marriage. Less loosey celebration is. While less loosey domicile governs that's the law of domicile governs the capacity of parties to get married, and where some of the components of these laws are not in existence in a marriage, there is the tendency to say that the marriage is a nullity. Now, under the statutory marriage in Nigerian law, you know that we have a plural marriage system. We have the statutory framework that is under the Marriage Act. You have the customary marriages, you have the Islamic marriage, and these marriage systems are all valid under the law in Nigeria. Now, this marriage, when it comes to the statutory marriage, the law of nullity would be either because a marriage is regarded as void or that the marriage is voidable. When we talk about nullity with regards to statutory marriage, you have to identify whether you are talking about a marriage that is void or a marriage that is voidable. When it is void, the law regards it as not existing at all, as if they never got married. It is void ab initio from the beginning. In the eye of the law, it did not take place. When you talk about voidable marriage, you are talking about the fact that the marriage existed at a point in time, but as at the point where it is annulled by the court, it no longer exists. And the differences between the two are very clear. Now, when you talk about the legal framework for nullity in Nigeria, therefore, you would have to look at the marriage type. If the marriage is celebrated under the Marriage Act, as called a statutory marriage, then you must examine the provisions of the Marriage Act and the Matrimonial Causes Act essentially, and particularly section 33, 34, 35 of the Marriage Act, which relates to invalid marriages. Then talk about a void marriage, you talk about the Matrimonial Causes Act, section 3 and section 5, together with section 35, 36, and 37, which constitute what they call bars to nullity. These are conditions under which when a party has established that the marriage is voidable because of proving the conditions under the Matrimonial Causes Act, the court can still say they will not annul the marriage. The logic of that is left for us to to determine, to say that if a marriage has been found voidable, the court can still say that they will not permit that marriage to be nullified. Then you talk about Islamic customary marriage. We know, with our knowledge of customary marriage, about how it is celebrated, the essential elements of a marriage. We sometimes talk about the formal validity and essential validity of a marriage. And you would see that the components of what we call formal validity and essential validity of marriage are what are the are inform what we call nullity of marriage. So when you do not meet the essential validity of a customary marriage, for instance, you talk about parental consent, payment of bride price, formal handing over of the bride, you're talking in the realm of saying that that marriage is not really valid in the eye of the law. So we'll look at that. So the ethnic customary law, the customary law of the place that applies to the marriage, the less loosey, would determine whether the customary marriage is valid under the law or not. And the same goes with respect to Islamic marriage. Then you have some other statutes that also regulate, validity of marriage under the law. For instance, the Child Rights Act 2003 as replicated under state child rights laws or laws of similar titles, which protect the interests of children, do not permit child marriage, for instance. And if you purport to marry a child or to betroth a child or to celebrate and conduct a marriage involving a child, that is somebody that is 18 years, under most of these laws, that marriage is a nullity in the eye of the law, and it's even a crime to do that. And then, so that's the law that applies generally to children. So it is immaterial, for instance, whether the marriage is statute or customary or Islamic. You do not conduct child marriages. Then you have same-sex marriage provision Act 2013, which attempts to regulate the sex of the parties to a marriage by prohibiting and criminalizing same-sex marriage and declaring it a nullity in Nigeria. You cannot celebrate it, and if you celebrate it, it's a crime, and anybody that conducts it has committed a crime. So this is a general statute as well. The marriage under the statutory marriage, when you talk about nullity, it's often said that it's either it is void or voidable. A void marriage, like I said, in the eye of the law does not exist at all. And under the Matrimonial Causes Act, you would see some of the provisions regarding void marriage and voidable marriage. The differences between them are many, some of which include the fact that when a marriage is regarded as void, as not having taken place at all, only the anybody can apply to annul the marriage. And we'll tell also if, for instance, one of the reasons that a marriage can be annulled is the fact that a party lacks capacity. Statutory marriage, for instance, is a monogamous marriage. Is a monogamous marriage. You should not have any other wife. So if a man is already married to Mrs. A and proposes to go and marry Mrs. B, Mrs. A can come and ask for declaration that that marriage be annulled. So anybody can apply to nullify a void marriage. Even when the parties are dead, somebody can apply to have marriage annulled because marriage usually has implications on the succession rights of people. So issues of nullity would usually arise. Issues of validity of a marriage would usually arise during, for instance, claims for succession and inheritance. In a voidable marriage, on the other hand, only the parties to that marriage would be competent to apply to nullify the marriage. And because we say that a marriage that is null, that is void, does not even exist in the eye of the law. Technically, you don't need to go to court to declare it null and void. For instance, in the example that I gave, that a man is already married, that marriage in the eye of the law to Mrs. B does not exist because the man does not have the capacity with the subsistence of a valid statutory marriage between him and Mrs. A to go and conduct another marriage with Mrs. B. So the marriage with Mrs. B, you may not need to even come to court to declare it a nullity. Although for the purposes of evidence, you would usually come to court and obtain a decree of nullity, So, but for a voidable marriage, it must be declared no, it must be annulled by a court of competent jurisdiction. The void marriage, like I said earlier, it is void from the beginning, ab initio. The voidable marriage remains valid and subsisting until the decree of nullity is pronounced. So it is a valid marriage up to the date where the court declares it annulled. The void marriage, because we said it does not really exist in law, it is not valid. Therefore, it cannot be subject to what we call bars, prohibitions that will say, oh, even though it's valid, it is void, we bar you from bringing a petition. Don't forget, we said you don't even have to bring a petition for nullity technically. But in a voidable marriage, even though there has been established the fact that the marriage is void, I mean it's voidable, the court may still bar the applicant from bringing and successfully having the marriage annulled due to some conditions that the law regards as almost like a fault. Even we talk about no fault divorce under the law now, almost like a fault. Then the fault, so there can be bars to a petition for annulling a voidable marriage, but there are no bars to annulling a void marriage. There are bars to to annulling a voidable marriage, which the court may impose, but there are no bars to annulling a void marriage. It is void, it does not exist in the eye of the law. So you cannot say you are preventing it from being annulled. The effective date of nullity is the date of pronouncement of the decree of nullity in a voidable marriage. It is until that date that the marriage becomes annulled. Otherwise, everything done before that date is regarded as good and competent in law. So, in summary, therefore, in conclusion, nullity of marriage leads to rendering a marriage non-existent because of the failure to comply with the lex loci celebration list or lex domicili. If you do not have the law of the place of celebration, if you do not comply with it, or if you lack capacity based on the law of your domicile, then the marriage may be regarded as void. As opposed to, for instance, dissolution of marriage, where the marriage is good and valid, but it has broken down, and so you get a divorce. So the nullity is completely different from dissolution. In dissolution of marriage, the marriage is valid and remains valid, but because the parties have problems and issues, they apply for a divorce, and they go their separate ways. The law of nullity, like I said earlier, reflects social development, the evolution of society, whether politically, economically, culturally, religiously. What will determine what is a what is nullity, or what is a null, or what is a void marriage, reflects the ideological shifts in society because of our understanding of who we are as a people and what our expectations should be. I must mention that because of the plural legal system, the laws of nullity regarding the various types of marriages are peculiar to those kinds of marriages, but there are some general statutes that apply across these statutes. So, in a nutshell, this is what we'll be looking at under the law relating to nullity of marriage in Nigeria, having looked at this general framework within which we work. I'll encourage you to like the video and share, and I'll see you at the next presentation.